Hi everyone, welcome. Can you hear me?
Yes.
Perfect. Okay, so my name is Leonardo Olhoge. I'm a Brazilian qualified lawyer based in Zurich, and I have the easiest part here, which is to say a few welcome words before introducing our mediator, who will take over later. So I work at MLL Legal, and I'm a Swiss Arbitration Ambassador, along with Caroline dos Santos, Baker McKenzie Geneva, Hernandes Sampaio, Valdo São Paulo, and Joaquim Muniz, Trent Rossi Watanabe, which is the Baker McKenzie office in Brazil, and whom I would like to thank for organizing this event. And what is Swiss Arbitration? It's a global platform for arbitration and mediation created by four organizations based in Switzerland, which are the Swiss Arbitration Association, the Swiss Arbitration Center, the Swiss Arbitration Academy, and the Swiss Chamber of Commercial Mediation. Our main task as Swiss Arbitration Ambassadors is to promote arbitration in Switzerland and the use of Swiss law in foreign jurisdiction. So I'd like to thank Arbitration Channel for supporting this event. Arbitration Channel is the largest arbitration social media platform. If you don't follow it on LinkedIn or YouTube, I strongly suggest you do. They organize several interesting in-person and online events, and their webinars are recorded and available on YouTube. And now, let me introduce our moderator, Lia Yokomizo. She's the perfect fit for this role. She's Brazilian, qualified in Brazil, but now is based in Lausanne, where she is legal counsel at CAS, the Court of Arbitration for Sport. Before joining CAS, she gained experience in law firms in Brazil and Geneva, and she also completed the MIDS LLM program in Geneva. Thank you, Lia. The floor is yours.
Thank you, Leonardo. Good afternoon to all of those who are watching us from Brazil, Switzerland, or just anywhere else in the world. First of all, I would like to thank the Arbitration Channel and the Swiss Arbitration Association, especially its Brazilian ambassadors, Leonardo, Caroline, Hernandes, and Joaquim, for the organization of this amazing event, and most of all, for inviting me to be here today, sharing this discussion with a team of absolute aces. I'm accompanied today by Raphael Favre-Schneider, who is an independent arbitrator in Zurich. Raphael has extensive experience with national and international litigation and arbitration, having worked with a large array of subjects ranging from commercial, sports, maritime, financial, commodities, construction, and just many, many more. Amongst her numerous credentials, she's also a CAS arbitrator, and we are very much lucky to have her in our list of arbitrators. Here with us today is Luca Beffa. Luca is a partner in Baker McKenzie in Geneva. He has extensive experience in international arbitration matters, regularly acting as counsel and arbitrator in both commercial and sports arbitration. He also handles litigation matters in a variety of industries, and like Rafael is a CAS arbitrator, we are very much lucky to have in our list. Last but not least, joining us today is also Bichara Bidon Neto. Bichara is a Brazilian lawyer and a partner at Bichara Mota Advogados, with extensive experience in sports law and international arbitration. He has acted in the first football-related case before CAS way back in 2003 and has served in the CAS Ad Hoc Division at the last 3 Olympic Games, acting as counsel for athletes and Olympic committees. Throughout his career, he has advised and represented athletes, clubs, and institutions in a wide range of legal matters across the global sports industry. Now, having presented our star-studded lineup, allow me to say a few words about the organization of the panel itself. Our panel today will be divided in 2 parts. In the first half, we will explore some of the procedural differences between commercial and sports arbitration. And on the second half, we will discuss a bit about cultural differences between Swiss and Brazilian lawyers, as well as those between commercial and sports arbitration practitioners. By the end, and if we have some time and if it's possible, we can open up for some questions, perhaps, if there are any. And so, without further ado, because I already spoke way too much for a moderator, let's finally start this panel exploring some differences between sports and commercial arbitration procedure. As I believe some of our viewers may not be so familiar with sports arbitration procedure and more specifically the CAS procedure, could I invite you, Rafael, to give us a brief overview of the different kinds of arbitration procedures that we have at CAS? And then once we have this overview, perhaps each one of our panelists can explain a bit more in detail about each one of these procedures. Rafael?
Yeah, thank you, Leah. Thank you, Leonardo, and all other CAS ambassadors in Brazil for the invitation. I'm very, very happy and honored to be here today and to discuss something that is very near to my heart, as I do both commercial and sports arbitration. I mean, in sports arbitration, there are mainly two different causes or actions. There's the ordinary arbitration, which is more or less similar to commercial arbitration, and then there's the appeal arbitration proceedings, which are appeals against decisions of national and international sports bodies. Both are regulated in the same code, in the Code of Arbitration for Sports. There are a number of regulations that apply to both proceedings, ordinary and appeals proceedings, and some others that are more special to each of those proceedings. The matters that are dealt with are in both sports related, must be sport related. Ordinary proceedings are proceedings where the parties have agreed in their contract on CAS as arbitration institution. Appeals proceedings are quite often, not always, but quite often the so-called forced arbitration, where the arbitration clause is contained in statutes or athlete contracts and others between the athlete and the federation. In those and the appeals proceedings, quite a lot of disputes arise from the WADA code, anti-doping matters, or other ethical matters. More largely, I would sum up, it's everything that's related to integrity in sports. It can be match fixing, or, as I said, doping, or ethical issues, mostly sanctions or eligibility issues that are dealt with in the appeals division. Commercial arbitration under the CAS Code is very similar to normal commercial arbitration, except that some of the rules are a bit more strict proceedingly, others are more lenient, more flexible, and but most particularly there are two aspects, but I think we will come to that later, to the differences. But most particularly certainly is the fact that the arbitration can go forward only if it has a relationship to a sports matter. I think that's for a short introduction.
Thank you, Rafael. So as you mentioned, there are ordinary proceedings, there are appeals proceedings. Perhaps you could tell us a bit more on the specifics of the procedure, how an ordinary case, what are the main submissions, what are the main steps of an ordinary proceeding?
Yes, I'm happy to do so. In ordinary proceedings, basically, it's a bit similar to normal commercial arbitration. It starts with a notice of arbitration that goes to the CAS court office, who then, if the matter is not obviously not covered by an arbitration clause that refers to CAS arbitration, will then open the proceedings and set a deadline to the parties for their submissions. This is something that is a bit different from commercial arbitration insofar as usually the deadlines are set by the panel, respectively by the CAS Code office. Something else that is also a significant difference, makes our lives as arbitrators easier, but might be surprising to people who know less, is the important role of the CAS Code office, who does the whole administration and writes the letters, so the orders that are rendered by the panels are transmitted through the CAS Code office, through the counsel in charge, like Leah and others. So they monitor the proceedings perfectly. Usually what happens is that there is one exchanger of briefs, of submissions, and a hearing. It can, however, of course, if necessary, there can be a second round of submissions. The parties can ask for the production of documents, but usually it's not in a form of red film schedule or whatever as we are used to. Usually they will ask for the production of document within their submission, and the panel will then decide whether such document shall be produced or not. The panel, of course, can also ask for the production of document if it finds that it is necessary to get more information or more document on certain aspects. Basically, then there's the hearing. Hearing is not very different from commercial arbitration. You will have witnesses who must have submitted a witness statement, but usually less long than in commercial arbitration, but it needs to indicate what the witness will probably be speaking about, or what they will be asked to some question on. And then after the hearing, an award will be rendered. In commercial arbitration, in ordinary proceedings, it's not very, very different. Well, there's one main difference, of course. Besides, it's that the parties can choose their arbitrator. They are party-appointed arbitrators, but the arbitrators need to be on the list of arbitrator of CAS. This is something that is discussed quite lengthily, also in whether that's a good thing or a bad thing. Some people believe that the list should be open. Personally, I believe that if you choose arbitration under the CAS Code, you know that you want specialists who understand sports matter. And funnily enough, it was quite surprising for me to be named an arbitrator in an arbitration not under the CAS rule, in a commercial arbitration under other rules, but where the parties agreed that the arbitrator must be on the list of the football arbitrators of CAS. So that shows the importance in certain situations and matters to have arbitrators who really know their subject.
Indeed. Thank you very much, Rafael, for this short introduction on the ordinary proceedings that we have at CAS. I believe that's one of the main differences between CAS arbitration and the arbitration carried out in other commercial institutions, because as I mentioned, we have several kinds of procedures. So it's not just the usual commercial arbitration as we know. Perhaps in a commercial arbitration scenario, we have also like an emergency arbitrator or some expedited kind of arbitration. But here at CAS, we really have very, very different procedures. And so Rafael presented to us the ordinary procedure, which is, as she mentioned, the one that's closest to the commercial arbitration we know. And perhaps Luca can now tell us a bit about the appeals arbitration procedure, which is essentially the procedure we have most at CAS. I think out of the almost 1,000 cases we have per year, the majority are appeals. So perhaps Luca, could you tell us a bit about the appeals arbitration procedure?
Sure, with pleasure. And first of all, let me thank as well the organizers for organizing this very interesting discussion and for inviting me, obviously, to speak. And welcome to everyone who is who is participating in this webinar. So when we talk about CAS appeals proceedings, maybe what are we talking about, first of all? So Rafael already said, we are talking about a specific procedure that allows parties to appeal against a decision which is rendered by a sport governing body. So this is already a unique feature of CAS arbitration that you don't have in commercial arbitration, because in commercial arbitration you normally handle procedure or disputes between two parties, whereas in CAS appeals procedures you actually handle disputes related to a decision issued by an association or a federation and a member. So the second thing I wanted to highlight is, and Rafael already alluded to it, that like in commercial arbitration, also in CAS appeals procedures, actually an appeal can be brought to CAS only if there is an arbitration agreement in favor of CAS. But what is quite unique also in sports arbitration is that most of the rules actually of the worldwide sports governing bodies in a variety of sports, such as football, tennis, or other sports like golf, for instance, all these rules already contain actually an arbitration agreement which provides that the decisions of the sports governing body must be submitted to CAS. So this is why we hear always often the term of mandatory or forced arbitration, as Rafael was mentioning earlier on. Maybe another specificity of CAS appeals procedures is that it is what is called a de novo procedure. What does it mean? It means that the CAS will basically rehear a dispute afresh as if it had not been previously heard or decided upon. And the CAS also can do it and will do it with full power of review of both the facts and the law. And again, this is quite unique of CAS arbitration and appeals procedures, and it is quite different from what we normally understand as appeals procedure in state court litigations as well. Maybe another difference or specificity of CAS appeals proceedings is that they are subject to much shorter and stricter deadlines than commercial arbitration. So very briefly, the appellant actually has to file a statement of appeal within a strict and short time period, which is usually of 21 days from the notification of the challenge decision, unless the rules of the sports governing body at stake provide otherwise. And if this time limit is not complied with, actually the appeal is inadmissible. Then what happens? The appellant has to file a full-fledged appeal brief, okay, within 10 days from the filing of the statement of appeal, and the respondent has to file an answer within 20 days from the notification or the receipt of the appeal brief. Extensions, short extensions are possible, but again, we are talking here about much shorter deadlines than in commercial arbitration or even in ordinary proceedings before the CAS. Another specificity of CAS appeals procedures, if compared especially to commercial arbitration, is that, like in ordinary proceedings at CAS, as Rafael mentioned, there is usually only one round of written submissions. And what is also important is that all the evidence that the parties wish to rely on must be put forward in the first and often also final submission of the parties. So the appeal brief for the appellant and the answer for the respondent. Again, exceptions are possible, but only if there are exceptional circumstances. Finally, like in commercial arbitration or in ordinary proceedings before CAS, a hearing is normally held unless both parties indicate or the panel decides that a hearing is not necessary. But the hearing is much shorter normally than in commercial arbitration. It usually takes 1 day maximum in CAS arbitration proceedings. And maybe another difference is that there is no transcript of the hearing, but the hearing is recorded. So these are, in my opinion, the main differences between CAS appeal proceedings and commercial arbitration on the one hand, and CAS ordinary proceedings on the other hand. Thank you.
Thank you, Luca, for again explaining to us a bit, giving this overview on the appeals arbitration procedure. As I mentioned, we have plenty of procedures. We still, apart from the ordinary and the appeals proceedings, we also have the ADD proceedings and the ad hoc proceedings. Perhaps Bishara could explain to us what these proceedings are, how it goes, what are the steps.
Sure, Leah. Hello, everyone. Thank you, Leonardo, for the invitation. It's a pleasure to participate and to have the opportunity to be with you today. As Leah mentioned, we have the ad hoc division, which operates during the Olympic Games, the Commonwealth Games, the Asian Games. The CAS, the ICAS, they nominate a list of arbitrators, a short list of arbitrators, I believe 10 to 15 names, around that number, and they bring those arbitrators to the Olympic to the place where the games are taking place. And the ad hoc division operates in very short time frames. The deadlines are really short. The decisions they usually are passed within 24 hours. It's a very interesting and rich experience for the counsels. Of course, I believe for the arbitrators as well, because it's very uncommon. We sometimes have to present written submissions within a couple of hours time frame. We used to hold case management conferences before the hearing, and all it's a bit frenzy the way it happens. We have witnesses to be heard. We usually deal with eligibility and disciplinary cases, doping cases mainly, and during sometimes overnight we have, as I said, very little time to discuss, to present evidence, to discuss the case, and to have a decision rendered within sometimes 24 hours or even less, because it usually happens between the phases of the competitions. Sometimes the eligibility of an athlete is being challenged, and the panel has to decide on it to allow or not the participation of the athlete in the next phase of the competition within this very short time frame. The anti-doping division, which is also, it's quite new in CAS. It started in the Olympic Games in Rio in 2016. It deals, as the name says, with anti-doping cases. It also operates during the games, but it acts also as a first division if an international federation nominates the CAS ADD as with the authority to deal in first instance with doping situations. The difference between the ADD and the appeals division is that on CAS Anti-Doping Division, usually we have only a single arbitrator deciding the case. If the parties agree to have a three members panel, they waive the right to appeal such decision. So this is also a distinction between the proceedings. I particularly I don't have much experience before the CAS ADD. Normally the doping cases we handle, they are decided by the appeals division, because it comes from FIFA or CONMEBOL, and they initiate in those federations, and then they reach CAS as an appeal. And my particular experience is more concentrated on the appeal division in doping cases rather than before the CAS ADD. But it's also a relevant tool for the practitioners to have this alternative to deal with the doping cases. And I believe, Leah, these comments cover basically the nature of both divisions.
Indeed. Thanks, Bishara, for this very short explanation of both kinds of procedures. As you mentioned, at CAS, we have many doping cases that they can be decided, as you mentioned, as a second or last instance before the appeals division, or before the ADD as a first instance. So essentially what happens is that the federation, instead of choosing to keep this whole apparatus for deciding doping cases on a first instance, they outsource the work to CAS. So they they write clauses in their statutes, essentially outsourcing these powers of prosecution and judgment in first instance. So the prosecution goes usually to the ITA, the International Testing Agency, and then they will start proceedings at CAS. But indeed, and another, as Bishara was saying, before the ADD, when the decision is rendered by a 3-member panel, the decision is usually not appealable. But if it is by a sole arbitrator, which is often the case, this decision can also be appealed before CAS, but then to the Appeals Arbitration Division. And that is also, I think, a very important feature to highlight at CAS, that all of our different procedures, they are set within different arbitration divisions, all which have a division president and a deputy, which make the important decisions prior to the constitution of the panel. And there's also a division, as I think, as Luca and Rafael mentioned, on the lists of arbitrators. So Rafael mentioned the football list. We have some lists that are specialized, but we also have divisions on the lists, because the arbitrators that decide ADD cases, they cannot be the same that decide the appeals, for obvious reasons. So there's also this institutional division between the chambers. Now, getting a hook here to something that Bishara explained regarding the ad hoc division is that the decisions are rendered in a very, very expeditiously manner. Because as you mentioned, sometimes you have an issue of an ineligibility that is declared today, and then the athlete has to compete tomorrow, and we need a decision as fast as possible. So moving on to a second topic that I would like to explore with the panel is the issue of urgent matters and how they are dealt before sports arbitration and commercial arbitration. So throwing the ball back to Rafael, could you explain to us a bit, Rafael, how expedited proceedings work in CAS arbitration and how do they compare with commercial expedited proceedings?
Thank you very much, Leah. Well, I would joke about it and say that compared to commercial arbitration, all CAS arbitration are urgent and and emergency arbitration. But that's not completely true. But it's true to a certain extent. What happens is that basically there are no rules on emergency arbitration under the CAS Code, as there exists in ICC or Swiss rules. In Swiss rules, you have provision for emergency arbitration, but in CAS, usually, if the panel has not been constituted yet, then such emergency decision would be rendered by the division president or his or her deputy. That is the I mean, the main difference, but because we have in CAS we have expedited proceedings, which is very often the case with, and these are so expedited that they are much faster than the 15 days of emergency arbitration under the ICC rules. The main difference between emergency arbitration and expedited arbitration is that emergency arbitration is an order. The parties must respect it, but it's not a final award. It's not enforceable as such. It does not bind the panel that is constituted thereafter to decide on the matter. Whereas in CAS, as there are no emergency proceedings, it is expedited proceedings, and these culminate in awards that are final and rendered. So that is one of the most important distinction between the two features. So expedited proceedings under CAS Code are proceedings where both parties agree that the decision must be rendered very, very quickly for whatever reason. Usually it is because there's a certain deadline, like the start of a competition, and one of the clubs wants to participate and has not been allowed to participate, and they need to have a decision very quickly in order to prepare for the upcoming season. Other situations are eligibility for board membership in a federation, when some people want to be eligible for a seat in an international federation and are not allowed to and go before CAS in emergency, well, not emergency, but in expedited proceeding, to have a decision on whether the fact that they were not allowed to be eligible as candidates was justified or not. So these are the cases, at least, that I have dealt with in recent times, and one of the most important distinction, I believe, is that usually the parties agree we need to have it very expedited, and then they discuss the timetable with the CAS Court office, and then the CAS Court office calls and said, okay, we have expedited proceedings. Today is Tuesday. We need a decision by Monday evening. Are you available? and that I think is one of the main differences, because in commercial arbitration, it would be then rather the panel who sets the deadlines and said, okay, we will render the decision by then and then. In ICC, we know if it's emergency arbitration, it's within 15 days. You have to render an award within 15 days. In CAS arbitration, it can be much less than 15 days. It can be, if it's ad hoc division at the Olympic Games, it can be a question of hours or days, but that can even happen outside of the ad hoc division in normal appeals proceedings under CAS that you have to decide very, very quickly. So I think that is one of the main differences. Usually in those cases, though, you will have the same than in other appeals proceedings, you will have an exchange of briefs, you will have a hearing, you will hear witnesses, but quite often, though, the decision will be rendered only as in the dispositive section of the decision, and the merits will follow a bit later, because that takes a bit more time usually to go through the whole thing and write the merits of the case. It's as Michel said before, it's stressful as counsel. I can tell you it's stressful as arbitrator as well, because you don't have a lot of time, and you want to render a decision that is correct, that is fair. So you spend a lot of time reading and listening, and then that's the reason why then you render the dispositive section and take a little more time to write the merits of the award. But I think that's the main distinction between commercial and CAS arbitration as to the expedited or emergency arbitration. I mean, it's expedited, not emergency.
Thank you, Rafael. Indeed, at CAS, we have this possibility of the parties agreeing to an expedited procedure where they will fix the deadlines for their submissions. And as Rafael mentioned, sometimes they will ask for a decision by a certain date, a cutoff date, for whatever reason. As you mentioned, perhaps there's a tournament starting, there's a tournament ending, there's an important game, so there's always certain reasons. And but that's a way of like expediting the proceedings itself. They usually those agreements are they regard the submissions. Perhaps Bishara could mention the other mechanism that Rafael briefly spoke about, rendering the operative part of the award prior to the merits as also a way of expediting the decision process at CAS.
Yes, of course. This is also a very useful tool that CAS provides in its Article 59 that allows the operative part to be disclosed before the full award. We participated in a very well-known case, famous case of Paolo Guerrero, the Peruvian football player, in which this was the situation. The decision was passed a little before the World Cup. It was in the end of his career. Peru didn't participate in the World Cup for many years, and he was suspended by the end of the appeal proceeding in CAS, and he would have he would lose the opportunity to be the captain of the Peruvian men's squad, Peruvian team in the World Cup after all those years. But CAS presented only the operative part of the decision at the time. So he reached the Swiss Federal Tribunal, saying, "Listen, I am about to lose the most important competition in my career, which is about to end. I don't know if I probably don't have the opportunity to participate again, and I don't have the full award. I don't know the decisions why I'm losing this opportunity." So he got an injunction. He got a decision from the Federal Tribunal allowing him to participate in the World Cup at the time. And then the decision in the end was confirmed. The CAS decision was confirmed, and he had and he remained suspension for the remaining time of his sanction. But this is an example of how it works in CAS. And in this particular case, he had the chance to participate in the most important competition of his career, despite being suspended in the end of the proceeding. Leonardo, do you want to say something?
Yes, thank you very much. I remember my Peruvian friends were very happy, but I have to disagree with you. The most important games were the ones he played for Internacional, my football club, around that time. It's more important than the Peruvian national team.
Fair enough. And here in Brazil, for instance, there is a CBMA, the Centro Brasileiro de Mediação e Arbitragem, which is the chamber who deals with their sports arbitration disputes. But we don't handle the doping cases in this chamber. So there is a provision for emergency arbitrator when we are dealing with sports arbitration in Brazil. No doping cases here. The doping cases, when allowed in international level, at least they are appealed to CAS. But in other matters, contractual matters and sports-related disputes that are dealt with in arbitration in Brazil, we have the possibility to nominate, to have an emergency arbitrator acting in the case, rather than the president of the division, as it happens in CAS. I really don't know if I understand that the necessity we have in sports arbitration for expeditious celerity, and it's really important. So sometimes not having the possibility to have an emergency arbitrator, as Rafael mentioned, is not a downside in itself. I think it's justified by the necessity we have in sports arbitration to have expeditious decisions, and I believe it's justified by this.
Yes, thanks, Bishara. So, as Bishara mentioned, we have these instances where we render the operative part of the decision prior to the merits, because, as Rafael mentioned, drafting the full award is something that takes time. So, many times what the athlete needs is a relief. So, we grant the relief, and then later we explain why we granted that relief. The problem is that sometimes, even if we expedite the procedure, even if we expedite the decision rendering process, that is not enough, because, as we mentioned, we have very, very urgent matters, and that's where the figure of the provisional measures come into play. So perhaps Luca could briefly explain to us how provisional measures work at CAS, prior to the constitution of the panel or after the constitution of a panel, and how do they differ in commercial arbitration practice?
Sure, thank you, with pleasure. So I think we have repeated many times that nature, the very nature of sports, so requires speed and effectiveness, and provisional measures are probably the most obvious option parties have in order to try to quickly and effectively protect their rights. What are provisional measures or interim measures? They are measures which aim precisely at protecting a right of a party which is at risk pending the resolution of the dispute on the merits. And maybe to make a link with the CAS appeals proceedings, the most often requested provisional measure in CAS arbitration proceedings is the stay of the appealed decision, which precisely aims at protecting the appellant's right to effectively challenge a decision by avoiding that it produces its effects before it can be reviewed on the merits. Maybe like in commercial arbitration, provisional measures at CAS are also subject to three main conditions. The first one is that there must be a risk of irreparable harm for the appellant. Second, there must be reasonable chances of success of either the request for arbitration or the appeal. And the third condition is that there must be a balance of interests which is in favor of the appellant, meaning that the interests of the appellant of being granted the preliminary relief outweighs the interests of the respondent. Maybe one of the main differences, or what is different in CAS arbitration proceedings in relation to commercial arbitration, is that while in commercial arbitration, parties can request provisional measures both from the arbitral tribunal and from state courts, this choice that does not exist in CAS arbitration. So indeed the CAS Code, Article 37, third paragraph of the CAS Code, provides that in agreeing to submit to arbitration under the CAS Code, the parties expressly waive the right to request provisional measures from state courts. And another difference, and Rafael and Bishara already alluded to it, is that in CAS arbitration, provisional measures can also be ordered by the institution itself, namely, and we heard it before, by the president of the relevant division, so the ordinary division or the appeals division. In commercial arbitration, the institution cannot order interim or preliminary relief. It is true, however, and we mentioned it already, that parties can ask for provisional measures to be ordered before the constitution of the arbitral tribunal in so-called emergency arbitration procedures. And in such a case, the institution does not decide itself, but appoints an emergency arbitrator who has to take a decision within a short period of time, usually 2 weeks. And maybe the other thing I wanted to add with respect to provisional measures at CAS is that the president or the CAS can decide whether it is the president indeed of the relevant division which takes the decision, or whether it is not that urgent to take a decision prior to the constitution of the panel, and then the issue is reserved for a decision of the panel once it is constituted. And this is probably the main also difference with commercial arbitration, because if you have an emergency arbitration procedure launched in commercial arbitration, the emergency arbitrator has to take a decision, whereas the institution at CAS, so the president of the relevant division, can also decide to wait until the panel is constituted. So these are the main differences I wanted to highlight with respect to provisional measures. Thank you.
Thank you very much, Luca. So yes, indeed, as we mentioned, time is of the essence at CAS. So we have these many ways to try to expedite as much as possible the decision making and the ways to grant relief to those who seek CAS, be it by means of expediting procedures, by requesting that the operative part of the decision be notified prior to the grounds, or as Luca mentioned, by requesting provisional measures, either before the constitution of the panel, which is granted by the division president, the president of the Appeals Arbitration Division, if it's an appeal, of course, or by the panel itself or sole arbitrator after their constitution. Now, moving on to the second part of our presentation of our panel, let's discuss a bit about these cultural differences between Swiss and Brazilian lawyers. I don't know who would like to go first to share some experiences on this one, but in your view, what are, if any, the major differences that you see when you're working with Swiss and Brazilian lawyers. And to this one, I will also invite Leonardo, who's always working with both Swiss and Brazilian lawyers. I don't know who would like to go first.
Maybe I can
Sure.
give you my view. I would actually distinguish between written and oral presentation of the case. In my opinion, most or the differences are more pronounced in the oral presentation of the case. I think, from experience, oral advocacy by Brazilian lawyers is more passionate. I mean, Brazilians are obviously more passionate than Swiss people, and Swiss people tend to be maybe more discreet and focus less on emotions, especially in evidentiary hearings, be it at CAS or in commercial arbitration. And maybe another thing that goes with it is that probably Brazilian lawyers, I would say, they tend to act maybe with more courage than Swiss lawyers when it comes especially to challenging procedural decisions of arbitral tribunals or CAS panels. Whereas I would say Swiss lawyers tend to have more greater respect of the decisions and the discretion of the panel, and they may avoid confrontation if not absolutely necessary. So these are the main differences I see, and between Brazilian lawyers and Swiss lawyers, especially at CAS.
But Luca, if I may add, it's my view in Switzerland that like when lawyers prepare present their opening statements in a hearing, they tend to read, like they have a transcript and they read. In Brazil, Bishara, I think we don't like it. Yes, when someone reads.
True. Yes, I agree with you, but I don't disagree with Luke. I believe the Swedes are more formal. We are more, let's say, emotional, rhetorical. Not only because of the nature of the Brazilian, which explains part of it, but maybe also because, and now today we have many lawyers trained and specialized in arbitration. When I started, when I did my first arbitration in CAS in 2003, I had absolutely no training in arbitration. Arbitration was not even practiced in Brazil because our Supreme Court was still discussing whether it was constitutional or not. And my background was from local courts, and I believe in local courts we used to practice in a more aggressive way in terms of language, emotion, more adversarial, a system more adversarial than the arbitration one. And it maybe explains a little bit of the behavior of the Brazilian lawyers in arbitration, at least in the past. Today in Brazil, as we started practicing sports arbitration less than 10 years ago, we also we still have many lawyers who deals with sports disputes, but with no background, no arbitration background. Their background is from local courts, and when they go into an arbitration, a hearing, the behavior, the adversarial nature shows a much more. So I believe it has both reasons to happen. The nature itself and the training, the use of advocacy in courts rather than in the arbitration atmosphere. This is how I would justify these main differences. But Lee, I think you are also in a good position to comment, because you are dealing with not only the Swiss and the Brazilians, but Europeans and South Americans in general. But Rafael, sorry to interrupt.
No problem. If Leah wants to answer that, no problem. What I just wanted to say, I agree with all of you. I believe that as in many other countries other than Switzerland, you have in Brazil, there's a much bigger oral tradition than a written tradition. So you're more used to pleading orally. In Switzerland and Leonardo, I must say, I don't like it at all. The reading of a written pleading. And it's strangely enough, it's not the case everywhere. It's very, very Swiss German. It's not like in Valais, where I trained, or in Geneva, people are more focused on oral advocacy. They train it much more, which is not the case at all in the German part of Switzerland. When I arrived in the German part of Switzerland, I was shocked to have lawyers reading 50 pages of pleading, and it's something that we can learn from Brazilians and others, and it's something that especially, and I think that's something that me as arbitrator, I'm very sensitive to the fact that written language is not the same than oral language. The structure of the sentence is not the same, the words are not the same, the whole system is not the same, the way you present is not the same, and I find it very boring to having to listen to a written submission that is read to me. I'm much more attentive if I have somebody who's really pleading, which is something that in South America and North America as well, but especially also in South America, you are much better trained than Swiss lawyers. So I think that's one of the differences. And then, I mean, the passion. It's not only a difference between Swiss and Brazilian. I think that the background of every lawyer that appears before us plays a significant role in his or her way of presenting a case, and that renders the whole thing much more interesting than doing only local courts in the Swiss German part of Switzerland.
Yeah, if I may add also to the discussion, to all that's being brilliantly presented, I think Bishara touched a subject that is indeed quite true, at least in my experience seeing lawyers from many parts of the world, is that indeed most of them are not trained in arbitration. They are trained either in sports or local courts, and they import their experience from the local courts to CAS. And contrarily to what Lucas said, I think one of the biggest differences I see is actually sometimes in the written parts, because the written submissions, they carry that formatting that they use at their local courts. So from Swiss lawyers, I see a lot of the very, very specific Swiss formatting, which is composed of like a sentence or an allegation, and then the evidence, like exhibit whatever, and then another allegation, and then exhibit whatever. And it's cut and it's presented in a very, very Swiss way. Like just by looking at the 2 seconds, I'm like, okay, that's a Swiss lawyer. And in Brazil, we have our very, I'm going to speak in Portuguese here, but it's excelentíssimo senhor doutor. So like your excellency.
Very formal.
Exactly, very formal, and also all the formatting. So we have here, and then the number of the procedure, even like visually. From 2 seconds looking at the petition, you can say, okay, this is an arbitration, an international, or even commercial. Now mixing a bit the subjects, you can see when it's a commercial arbitration trained lawyer that's doing sports, happening to do sports, and they also have that very ICC layout kind of in their submissions. And if it's Brazilian sometimes, or if it's from other parts from Latin America, you can see also very the way their submissions are formatted and how formal they are as well. I have many cases in which, for instance, for a power of attorney, they will give me a notarized 50-page long power of attorney, general power of attorney from the president of the club and send me the copy of the ID of the president of the club. And I'm like, I just need a piece of paper signed with the name of the principal. And for me, the most important part is that the principal confers representation powers before CAS in arbitration. Sometimes they give me all those very beautiful, very complex powers of attorney, and they don't have powers for arbitration or powers before CAS. And I have to go back to them and say, I'm so very sorry you spent all this money and time notarizing this very beautiful power of attorney, but that's not what I need. And I think there's also this cultural difference. I think in South America, we're much more formalistic than perhaps in Europe. And so these are also some of the cultural differences that I observe. But now moving on to a different part of the discussion is that, well, it's clear, I think, for us that cultural differences come into play in terms of advocacy styles. But I would like to see your views when it comes to differences of advocacy styles between lawyers who work strictly with commercial arbitration and those who work strictly with sports arbitration. I don't know if you have any anecdotal cases. Well, what have you seen in your experience?
I would say first and foremost, I believe that if in sports arbitration, knowing the sport is more important than knowing the arbitration. So if you have lawyers who are experienced in arbitration but do not understand the subject matter of the problem, that for me is much more difficult to deal with. And as an anecdote, I can tell you, I had a counsel who represented an athlete in a doping case, and this lawyer was an experienced arbitration practitioner, but had absolutely no idea about doping. And his main argument at the oral hearing was, well, how can one expect an athlete to understand the WADA code when even I don't, and I spent yesterday a few hours reading it? That's one of the examples, and it's something, and I mean it's for, I always say also to younger practitioners or students who ask me, I say, I mean, don't forget, arbitration is a procedure. And if you don't master the subject matter, the real law that will be applied by that procedure, it's useless, because you cannot heal something through the procedure only, in my understanding. So that's, I mean, it's one of the examples, and I find that quite often commercial arbitrators who arbitration practitioner lawyers who have a reputation in their field tend to be a bit snobby about sports arbitration, and or then I mean, that's the experience I made quite often. I said, yeah, well, sports, and then are very surprised about the specificities of the rules and regulations, and well, they fall a bit down from their pedestals then. And I think, yeah, for me, that's, please first and foremost be a sports lawyer, and if you're less trained with arbitration, we can help with that, especially in CAS. I mean, we have an excellent CAS Code office who can assist. We have counsels. If you ask them, they will respond. And also the arbitrators are used to having a bit less arbitration specialized lawyers, but really lawyers who know sports law. Has Luca disappeared?
Indeed, I cannot see him. I think we lost Luca.
Yeah.
Yeah.
I hope he joins us, but I think we continue.
Yes.
Yeah.
Bishara, would you have some anecdotal cases
Yes,
that you've seen over the years?
Yeah, I actually like experience in commercial arbitration, so I have only a partial view of this context. But I think in sports arbitration, we used to be more flexible, as we are dealing with appeals, arbitration in an appeal proceeding, which is the case was heard already in the first instance, and in CAS in 90% or 85%. I don't know what's the statistics today, but the major part of the cases are dealt in appeals proceedings. So we tested the evidence already. We have, I'd not say simpler cases, but somehow we can expedite the proceedings in the appeals division. So I believe the sports lawyers, they tend to be more flexible. Not, I don't know if I can say that, more pragmatic as well, but I believe there is some level of informality, and which helps the case to be solved in a swifter way. So this is how I see.
Yes, indeed. I think building a bit of a bridge between what Rafael and Bishara said, at least in my experience, also coming from a commercial background and coming to CAS and then having to, say, learn the sports law. There's an arbitrator I very much like, and he always refers to it as the liturgy. And the first time he said that, I was like, no, liturgy, that's like some church thing. And then my father said, you ignorant person, like liturgy is like procedure. So he was asking me what was the CAS liturgy, because at the end of the day, each arbitration institution has their own little twigs here and there. And I believe what Rafael said is indeed very true. It's like, nobody just knows arbitration. You need to know that specific kind of arbitration, and be it on the material side of things, but also I think in the procedural side of things. And as Michelle said, I see a huge deal of informality in sports arbitration that I don't see, for instance, in commercial arbitration. I think that commercial arbitration started as an idea of let's be more flexible than courts, and then more and more they became not as flexible as they would like to be, whereas sports did remain a bit flexible. So as I think it was Luca that was mentioning that in appeals proceedings, you need to have the witness statement of the witnesses, but sometimes the parties just they don't nominate witnesses beforehand, and they just nominate them later. And sometimes those witnesses, which never in 1,000 years would be accepted in a commercial arbitration, they are accepted in CAS because there is this flexibility, because I think there's more informality. I don't know if Luca has anything to add. I think now we got Luca back.
Yeah, I'm sorry, I was cut off. Probably the network is better in Brazil than in Switzerland. That's the conclusion we can take. So I didn't follow all the discussion. What maybe I wanted to say, and it has a link with what Rafael was saying before, is that I think that sports arbitration lawyers focus more on facts than on law, and it's probably also linked to the fact that they know the sports, they must know sports, and I think facts are more important than law in most of CAS cases, at least from the point of view of the counsel. And legal submissions, I would say, tend to be a bit more substantial in commercial arbitration than in sports arbitration. And maybe another thing that I don't know if you touched upon it, the evidence or the amount of evidence is much more important in commercial arbitration than in CAS proceedings. And there are, in CAS proceedings at least, there are practically no or very few requests for production of documents, whereas in commercial arbitration, production of documents are rather the norm than the exception. So these are the other things that I thought were important to say on top of what Rafael said. And sorry, Bichara, but I didn't hear what you said actually. And sorry if I repeated anything that was already said.
You didn't. You said other things, and in relating to that, and that's something that we have not discussed before. One difference between commercial and sports arbitration, but that plays a role when you speak about the evidence and the document production requests and so on that are less extensive in sports arbitration. I believe that this might partly also be because sports lawyers are more practical. That's one thing, but also because they know that they will not get back the whole amount they spent on finding the sometimes unnecessary evidence. In commercial arbitration, I mean, it has taken it has changed in recent years. I believe it's getting more and more and more, and the submissions are bigger, and the evidence is bigger. And I'm not sure if they would continue having this much evidence and these big submissions if they would know that the large part of it would not be reimbursed. And I think that's one of the good things. I mean, maybe the lawyers are not so happy about the fact that they just get a certain amount, but not all their costs back, or the parties might not be happy. But I believe that this is measures to streamline also the proceedings, to make them more efficient and faster.
Yes, to add to what Rafael and Luca said, I think the idea that the submissions are not as substantial in sports arbitration is also connected to the fact that the deadlines are much stricter, they're much shorter. In commercial arbitration, you have, 60 days, 90 days, depending on what the parties manage to negotiate when they are negotiating their timetables. And at CAS, you have like those 21 days to file your statement of appeal, which cannot be increased in any way. So you have to present, and then you have those 10 days for the appeal brief, which of course those can be extended, but still it's never as much as you would get in international in commercial arbitration. So I think perhaps also there's the difference, the submissions, because I think it also has to do with the time, exactly because the procedure is so much faster. The lawyers don't have the time to be looking where to tweak this, tweak that, or like all these evidence. And also, I think it also has to do with the nature of the dispute, because many times we are dealing with factual things. So it's the evidence is witnesses. So it's a doping case. So what I need is the witness, the doctor, because my story is that the doctor gave me, so I'm going to call the doctor. So I think it also has to do with the kind of production of evidence. Of course, if it's like a contractual dispute, agent disputes, they have lots of document production, because many times their remuneration is based on what the player makes, and they don't have access to those other documents. So there you have some degree of request for document production. But other than that, many of the documents have already been presented in the first instance. We're dealing with appeals arbitration, so we already have the documents. Many times it has to do with rules. So we're dealing with purely legal discussions, so there's not as much evidence as well. So I think that as well may be a difference, and reason why there's this difference on how substantial the submissions are in sports and in commercial arbitration as opposed to sports.
Sorry, I have a question here regarding document production, which was one of my favorite topics. Rafael mentioned later that we don't use in sports arbitration the red fern schedule. But what's the threshold? I mean, you still use the IBA rules and the materiality requirements, or which standards you apply to decide if you allow or not in a document?
Yes, I mean the standards are the same. The materiality, the standards are the same, but it's they said there is no reference schedule because it's less formal, and there's not a separate phase in the proceedings for document production requests. So if you file your submission and you need a document, you will mention it in the submission itself and say, I want that document, and then the panel will decide whether the other party shall produce it with the other submission. That's usually how it happens. And I do find that quite an efficient and time-saving and money-saving manner of doing it. But yeah, I mean, there is document production. I had it several times, but it's not the norm in appeals proceedings because the documents usually already have been produced in a way or another. But it happens. Or you know that somebody wants not a copy but an original of a contract because it might have been falsified or not be the real one. This kind of things happen, but it's within the submissions.
Okay, thank you.
Yeah. If I may, I was thinking about something Rafael mentioned, and in my experience on the sports side, the most complex cases in terms of evidence are the doping ones, rather than the contractual disputes where we have the documents, we have the witnesses to confirm this and that, and the evidence is there. But in the doping cases, we need to sometimes to request the document packages, the B sample, the opening of it. Sometimes the athletes, at least in the third world countries or South America, they don't have even resources sometimes to open the B sample. And in some more complex cases, we need expert reports, tests, hair tests, and nail tests, and a very complex set of evidence to be produced. And in the end, there is a reimbursement of legal fees, something like 3, 5, 10,000 Swiss francs that doesn't cover part of it, and which is, it sounds unbalanced in those cases, because in the other ones, in the appeal cases based on documents only, we could understand. But in those others, in more complex evidence, where you need to spend more money, more time, and sometimes without even having the resources to do so, it sounds a bit unfair to me. But just to leave this idea on the air. Yeah,
I understand, and I agree with you to a certain point. I agree with you. And when I mentioned that before, it was more like the arbitration costs that are fixed, but also the compensation. I mean, it's always a very difficult decision to make on the cost, how much you will compensate or not, and it is true that sample Bs, but usually all these steps have already been made in the first instance. So so the costs of the CAS proceedings themselves will be less than the cost of the first instance proceedings, I would say. And we are not supposed to state on the cost of the first instance proceedings.
Well, thank you all very much for those comments. I think it's been a great, enriching discussion, because this is also a Swiss production. We're already running late, so unless Leonardo gives us the green light, we'll be here all afternoon. I don't know if we still have time for questions, Leonardo, how it works, or no questions.
I mean, I think the chat is not working. Let me check on YouTube if there is any questions. No, I don't think we don't have any questions.
Okay.
So I think we can close. Thank you very much, everyone. It was a pleasure. And I mean, we can never underestimate the cultural difference. This is my day-to-day. And it's sometimes I have Brazilian clients. Like in Brazil, we always file requests for clarifications when you lose. our embargos de declaração. If you lose, you file a request for clarification, even if there is nothing to clarify. You just want to show that the arbitrator was wrong, or the judge. And sometimes Brazilians want to do this here in Switzerland. I have to explain, no, it's not possible. Or they always want to challenge the arbitrators. Yeah, no, this is not the case. It's also clients' expectations. So it's important that we do arbitration, have to bear in mind these cultural differences and balance them when you are deciding our cases. So thank you very much. I don't know if anyone else wants to say a final word. No.
I think perhaps just on behalf of the whole panel to, again, thank you and all the other ambassadors again for the organization of this event and for having us here today. It's been a pleasure. Thank you very much.
Thank you very much.
Yes.
Bye-bye.
And thank you very much, Arbitration Channel, for the organization. Everything worked really well. So perfect. Thank you very much.
Thank you, everybody.
Thank you. Bye-bye.
Thank you.
Bye-bye.